The Supreme Court denies Jack Smith his petition for certiorari. He's having a bad day, got a lump of coal for Christmas because he wanted to really fast track the Trump trial. Wanted March 4th to happen. The day before Super Tuesday, they were going to be in there in trial, but not anymore. This is a big loss for them, and they were panicked. This is Jack Smith submitting motions all over the place, asking Chutkan to accelerate, asking the Court of Appeals to accelerate, asking then the Supreme Court to leapfrog the Court of Appeals because it was taking too slow. He was like, let's go now. But the Supreme Court said, what's the rush, man? We're not as partisan and political as you are. We don't think that the election is an urgency. And so Jack Smith is going to have to go through the regular course, the regular process. And it is good news because, man, they had all their eggs in this basket. Now they're going to have to figure out what else to do. They're going to have to look to Florida with Judge Cannon. Are they going to accelerate that case now? Or are they going to go back to Big Fanny's case with Rico and focus on that one? Or maybe they'll wake up Alvin Bragg and say, hey, it's time for you to get back on the horse and start prosecuting Trump again. And so who knows? Maybe they'll indict him again. Maybe we'll see a superseding indictment. But the point is, delays here are exactly what they do not want. This was a political attack job, and they needed the attack to happen on time. Now that it's not happening on time, what are they going to do? Well, we'll have to wait and see. But the order, the delicious order from the Supreme Court, often comes in the simplest form, one sentence. This is what it looks like. Boom. Friday, December 22nd. Merry Christmas, Jack! United States versus Trump. The petition for a writ of certiorari before judgment is denied. And you can see that is a very fun one. It comes on the back of the docket. You can see there was a ton of activity. And we spent some time here yesterday. And if you missed that segment, I would really encourage you to watch this one. The one where Edwin Meese said that Jack Smith is illegitimate. This is the Supreme Court docket. You can see Jack Smith was here. He filed a petition. He filed a motion to expedite. He's like, let's go fast. We have to convict Trump. He filed another motion to expedite. Trump filed some responses. Edwin Meese and those amazing law professors filed that one. And then we had the brief of the states, which we'll take a look at. And then Jack Smith responded, begging SCOTUS, please accept the case. But Supreme Court came back 3 days before Christmas and said, your petition is denied. Now, there's some good stuff in some of these filings that led to this, but Jack Smith is not having a good day, not having a good week. You can see this guy, even Marc Elias, the Democrat super lawyer, who is very upset with Trump, says, breaking, the Supreme Court denies Jack Smith's request to hear Trump's immunity appeal. The DC Circuit hearing is on January 9th and no SCOTUS consideration until after. And we're going to tease out exactly how much time there is because Trump has a lot of time. You can say 45 days at the Court of Appeals and 90 after the fact. And Jack Smith even admits that, which we'll read. So Marc Elias says current trial date is in jeopardy, which is an understatement there, Mark. Yeah, it's in jeopardy, all right. Because remember what happens. Remember when the case went up on appeal in mid-December, it stopped the clock. Okay, the clock was paused. That's it. And so once this case is ultimately decided in the Court of Appeals, you don't just kind of go back onto the same timeline. You have to revert all the way back, right? You get all of that additional time. And so Trump is going to say, as he is right now, I'm not working on the January 6th case at all. I haven't even thought about it. In fact, look, my file's closed. It's in the closet because I'm working on the appeal. I can't play two games at the same time. And so when he goes back from the Court of Appeals, it's like he never left the DC Circuit. Okay, it's not like he can continue to work there. You rewind the clock, and all that time between mid-December and whenever this is resolved is basically deleted, gone. Doesn't count against Trump. He gets all of that time back. And so he's going to add all of that time onto the calendar. And when is that going to push the trial? Well, probably like in the middle of the election, like November, October. And they're not going to want to schedule the trial then. And so it's going to probably get bumped until after Florida. And then beyond that, maybe into 2025. We'll have to see. So this is Marc Elias, very unhappy about it. Techno Fog, another friend of ours here, says this one says the Supreme Court has denied special counsel Jack Smith's request for an expedited review. He says there's not going to be a trial before the 2024 election. Ooh! And he's a sharp cookie over there, so you know that means something. Now he says, no mistake, this is a big loss for the special counsel. And absolutely, we've been here for months now saying that Jack Smith and Judge Chutkan, they were just, pinky promising each other, we're going to have a March 4th trial date. This is going to be something that is resolved well before the election, because if they postpone it a little bit too much, then it's right into the election season. So March 4th was kind of the end line for them. And now they are having to figure out what to do. So it's a big loss. Judge Chutkan is not happy about it. This case was taken away from her. And Jullie Kelly responded also back to Marc Elias and said, hey, not in jeopardy, Marc. Okay, this is a nail in the coffin for the March 4th trial date. Oral arguments in D.C., the appellate courts are set for January 9th, and it could be weeks until after that. And that order will then go up to SCOTUS. And so very, very good news for the defense because they want due process. They want equal protection under the law. Judge Chutkan and Jack Smith say they don't even need to read the discovery. They don't even need to look at the evidence. Well, we disagree. Jack Smith is denied. What a glorious day. So that is a big one. Now, this is what Jack Smith said right before this denial, okay? He was basically begging the Supreme Court, don't you do this to me. Now, here's why. They say, this is the reply brief for the petitioner, saying, in this case, he says that, this is before the Supreme Court denied him, even if the government prevails in a timely issued opinion, the default rules give Trump 45 days to seek a rehearing en banc, okay? So it's going to go to the Court of Appeals. It'll be heard by the panel of 3. Then it will go back to Trump. If he loses, he can re-request for a full rehearing. This is according to Jack Smith. And that rehearing, he's got 45 days to do that. So from January 9th, right? So 1/9 is going to be the scheduled date. Then we're going to have a length of time until we get a ruling. Okay, so we'll get a ruling at some point, however long that is. And then from there, Trump will have, let's say, another 45 days to go to the Court of Appeals again for a full rehearing en banc. However long that length of time takes, we don't know. Okay, then they've got to issue a ruling. So you've got another time here and another time here. And then suddenly, what happens if it comes back, let's say, adverse to Trump at the Court of Appeals? Well, this whole thing now is going to start back up at SCOTUS. Okay, so now we go appeals to SCOTUS. And how much time does he have for SCOTUS? Well, even Jack Smith admits it right here. 90 days then to seek certiorari. So then he can wait another 3 months, 90 days there. Okay, so now we're just doing the math. March plus, let's say, 3, 4, 5, 6 months. That's election season. So is the judge going to reschedule this like in October or November? I doubt it, right? So even Jack Smith is acknowledging, he says, look, regardless of whether respondent uses or even allowed that much time in this case, the available time would necessarily be reduced by the length of the proceedings in the DC circuit. So basically begging them, please hear this. The same approach is warranted. Certiorari before judgment allows the court to set its schedule now and resolve this issue quickly. You know, they really needed it. Now they're out of time. Now, I also wanted to share this part of conversation with you because yesterday we talked about Jack Smith being illegally constituted, right? He's not an appointed U.S. attorney who was confirmed by the United States Senate as is required under the Appointments Clause. Instead, Merrick Garland just picked him up out of somewhere and brought him in here and said, you're special counsel. Well, Reagan's former attorney general is the person who submitted this motion saying Jack Smith, the so-called, quote, special counsel, is not a special counsel at all. Now, Jack Smith is responding to this, and we read through the full opinion, okay? It was 50 minutes or so of that full brief, and it was very good. But this is what is happening now. They say Jack Smith is responding to this, kind of, right? One paragraph. He says, by the way, okay, Supreme Court, like there's another brief that came into your courtroom, and it came in support of neither party. And it raises an argument that Trump has not raised at any point in this case. Trump has not mentioned it, so you guys should not even think about this. He says that the special counsel, so-called, lacks the constitutional authority to bring this prosecution. Now, Jack Smith says, look, even though they said that and submitted that here, this court does not generally entertain arguments that were not raised below and are not advanced in this court by any party. The sound reasons supporting adhering that practice here. This court rejected that in Nixon. And remember that in the filing from Edwin Meese, they already brought this up. Edwin Meese confirmed, he said that that was dicta in Nixon, and it wasn't actually on point to the issue that is relevant here. And they say the DC Circuit already rejected that stuff, but remember, they already dealt with that. So they say no reason exists for the court to allow the amicis, which is Edwin Meese's unsound arguments, not presented by a party, to affect the court's grant of the petition. And so we don't know if Jack Smith or that had anything to do with anything, but it certainly is here. So that is what Jack Smith submitted. Now, the reason we don't know whether it had any impact or not is because the answer, the order from the Supreme Court is just one sentence. We don't know even what judges were in on it. You know, was it a unanimous opinion? Was it 5-4, 6-3, or what was the breakdown? We don't know. Just one simple sentence. We are not accepting the case here today. And so very, very good stuff. Now, the other thing that may have been conducive to the Supreme Court not accepting certiorari is this. Attorney General Andrew Bailey and 18 other states across this country submitted a brief against Jack Smith, saying, you can't just jump up in front of the line, man. You got to stay in line, cheater. Get back in line. They say the DOJ's attempt to accelerate the prosecution, to prosecute Trump, is blatantly partisan. There's no good reason to do it. Jack Smith couldn't even articulate the urgency in his own petitions, saying SCOTUS must reject it. And so let's take a look at that petition, because you can see if your state is on board. This is the petition of Alabama and 18 other states as amici curiae, friends of the court, friends of the issue. Let's see what states are here, shall we? And follow along at home to see if your state made it. We've got Steve Marshall, Alabama, is the person who is bringing it, along with his assistant attorney generals. We've got Alaska's here. Florida's in the house. Shout out to Idaho, our friends in Indiana. Iowa. Kentucky's on the list. We got Louisiana, our friends in Mississippi. Shout out to Missouri. Wyoming, our friends in West Virginia. Utah, the great state of Texas. South Dakota. We got South Carolina here. North Dakota's in the house. Nebraska and Montana. And our useless attorney general is not on the list for Arizona. And so shame to her. But this is what they say. They say all of these states are now respectfully submitting this brief as amici curiae in support of Donald Trump. They say the issue before this court is a narrow one, and while the question of a president's immunity from prosecution is self-evidently important, the question here is whether the public interest requires immediate determination of that question. Now, as agents of the public, amici, the states, we offer a different perspective than Jack Smith and the deranged thugs over there at the so-called special counsel's office, which is illegal. The United States petition repeatedly proclaims, but never explains why. Why do we have to go so fast, Jack? Why is it of imperative public importance that Trump's claims of immunity be resolved so quickly, so fast? They say the silence of that explanation is very telling, and it's troubling indeed, suggesting that the United States' demand for extraordinary and immediate relief is driven by partisan interests and not public interests. True. They say here, a petition for a writ of certiorari before judgment, the states are writing, is granted only upon a showing of imperative public importance. But unsurprisingly, when the United States has previously petitioned for a writ of certiorari, it spelled out the timing concerns. Like, it was clear. We got this problem, this problem, this problem, this problem, this problem, this problem, this problem. But that's not the case here. To be sure, the United States declares, quote, it is of imperative public importance that these claims of immunity be resolved immediately, so that if the claim is rejected, so the trial can proceed as promptly as possible. Yes, Jack, but why? But the United States, Jack Smith, never explains why waiting a few additional months for the Court of Appeals to do their due diligence would damage the public. Instead, they offer a tautology, circular reasoning. They say if the court agrees to review the case sooner, it can review the case sooner. Thanks, guys. That is no reason to justify the prosecution's extraordinary request. They say, which naturally raises the question of what the real reason is for demanding the extraordinary deviation. Well, they say, of course, it's because Trump is currently a political candidate for the Republican nomination, and the United States waited more than 30 months to charge him. The petition's repeated appeals to the March 4th trial date thus suggest a partisan purpose and not a public one. Any such reason would be an improper basis for invoking this court's rarely exercised power to invoke a deviation from this. The court notes that it should be an imperative public importance, not an importance of a particular candidate like Joe Biden or the Democrats. Now, because the United States failed to show this, they should be denied. They say no one disputes the question of a presidential immunity, that it's a very important issue. We got that. Tremendous public significance. But that doesn't mean we just automatically bypass the normal appellate procedure. It's got to be imperative public importance. And there's got to be a time component. It's got to have an immediacy requirement to it. It's not just because, like, you hate Trump a lot. You need more than that. Say here, other cases would be extremely rare. The court deviates from normal practice when there is a truly urgent need. So here's one example of what would be a true urgency, not because they hate Trump. During the Korean War, steel production was pretty crucial, but steel workers declared a strike, and that immediately jeopardized our national defense. If you don't rule on this, we don't have steel. If we don't have steel, then we don't win the war. We all die. So to avoid catastrophe, the federal government seized the nation's steel mills. Nice. Now, after the district court entered the preliminary injunction against the government, this court granted cert 3 days later. Why? Because it was urgent. Same thing with the Iranian hostage crisis. The president reached an agreement with Iran. We had to get it resolved quickly, and they did. War and hostilities are a appropriate, not because you just hate Trump, saying that the court has long recognized the immediacy rule. You don't get to just go fast because you hate Trump. We know that in United States versus Texas, the federal government argued that a nationwide vacatur entered weeks prior was already disrupting the efforts. And so accordingly, they acted. And there's a couple other examples of that as well. But what the US government, what so-called special counsel Jack Smith says, is that here, that their rationale is urgency, saying to afford this opportunity to grant review now. That's their urgency. Now it's unclear why the ordinary process wouldn't get that, but he says, look, this is not an argument, whatever they're saying. It's a tautology. If the court does not review now, it cannot review now. But why is it imperative to review now, is what he's saying, right? You guys are just kind of talking in circles. Now, one searches the petition in vain for Jack Smith's answer. The best the United States offers is that immediate review would permit respondents to proceed as promptly as possible. That's great, but going fast is not in the public interest. Every prosecutor should act with diligence, but that doesn't make it imperative. Like, doesn't every prosecutor want promptness to their cases? But that's not imperative. So the government has not shown an urgent need in this case. Is there a war? No. A hostage negotiation? No. Or a border crisis at issue? Well, there is, but not here. And the petition cites no authority for its position to accelerate all of this. So the government's recitation of the trial date keeps saying March 4th, March 4th. We know it's quite meaningless, as every prosecution that goes to trial has a trial date. So stop barking that, Jack. Now, even in other prosecutions that the federal government is deemed to be of tremendous public importance, even in ones involving January 6th, they let the appellate process play out. The Fisher case, another J6 case, which is working its way up at the Supreme Court right now, the government did not seek certiorari before judgment. In the other J6 cases, they didn't let it go through the normal course. But what's the urgency here? In fact, the government itself sought an extension in this court. But now that case has been pending for almost 3 years. Other cases have also been going on for a long time. But why this one? Why does Trump's need to go so quickly? Well, it's because it's political. There is no comparable exigency here. Nothing that needs an urgency. There would be nothing unseemly about ordinary appellate review and no, quote, confrontation caused by postponing this while the appeal is pending. The United States, Jack Smith, and the so-called special counsel's office, their entire argument is that the court should preserve the trial date of March 4th because they should preserve the trial date of March 4th. Thanks, guys. Without more, that's not enough. And so if there is no public reason for immediate review of this, then the court shouldn't grant it. Now, while it has no legal significance here, the United States preferred trial date has tremendous political significance. Saying the trial schedule coincidence with the presidential primaries is not lost on the public. It's literally the day before. Devoid of arguments, the petition practically begs the public and the court to consider the political consequences. And President Biden's own remarks at the start of the investigation didn't help. When he was asked to reassure foreign leaders that the former president will not return, Joe Biden, the current president, said, well, we just have to demonstrate that he will not take power if he does run. I'm making sure he, under legitimate efforts of our Constitution, does not become the next president again. Okay, that's our demented, tyrannical, insane president who's saying that he's going to use the federal government to take out his opponents. And the country just like marched on like no big deal. The following week, so-called Jack Smith was appointed to oversee this case, right? He comes out, he says that I'm taking constitutional steps to make sure nothing happens, which are not constitutional, right? It's not legitimate at all. Guess what? Week later, Jack Smith's here. Perfect. So normal order should prevail, they say. The United States insisted in the district court, but nothing about this prosecution has been normal. After the August indictment, August 1st, the United States demanded jury selection begin in December. So August to December to prepare 11+ million pages of documents. It's the most disgusting. It's like the Count of Monte Cristo. Like, that's the same due process. It's like not even a trial. And they asked for that. That's Jack Smith, the so-called justice team. So shortly thereafter, the prosecution dropped 11 million pages of documents derived from the investigation of multiple agencies, dozens of different types of witnesses, and they rushed to trial after 2.5 years when they could have brought the case, but they didn't. Now, in the defense's view, the federal government wants a show trial, not a speedy trial. And the district court assured that Trump will be treated exactly, said Judge Chutkan, with no more or no less deference than other defendants. But the same court compared this case to a Boston Marathon bombing and the September 11th attacks. Citing President Trump's considerable resources, the government then neatly organized the discovery. Okay, that's Molly, highlighter girl. She had everything like in binders and like tabs, all 11 million pages or whatever. I don't know how tall it was. But she said, we already organize it. And we know what the defense is going to need for their defense, and we organized it for them. And Judge Chutkan said, that's really nice of you. You're really smart, Molly. Nice job. And Molly's like, oh, thanks. So, and its own prediction, it said the defense wouldn't review the 12 million pages anyways. She's like, we just dumped a bunch of useless garbage in wheelbarrows on their front lawn. The district court largely acquiesced to the United States and set trial for March anyways. The court said trial's not going to yield to the election cycle. We want this to stay. And so on December 1st, the district court Chutkan then denied President Trump's motion to dismiss, and we sought an appeal. Now, the DC Circuit set a very uncommon schedule without explanation, an opening brief due on a Saturday, December 23rd, which will be tomorrow, and a response brief due Saturday, December 30th. The reply brief is due January 2nd, and then we've got oral arguments on the 9th, which we'll cover here. Be sure to subscribe. Still, the United States wants more than a compressed trial schedule and an expedited appeal. To keep its inviolable trial date, the United States seeks one more departure from normalcy. It admittedly extraordinary request. It tries to bypass the Court of Appeals. There is a new novel question that is vital to our democracy. We've got the cornerstone of our constitutional order being discussed here. And rather than allay fears of any of this, they just get in their stupid filings at that office, filing March 4th because the public needs this. They're like, we need this, man. Jack Smith's like, I really need this, man. You don't know how bad I need this, Judge, please. It should go without saying that interference with Trump's political campaign is not a legitimate reason to seek access to this court. The primary duty of a prosecutor is to follow the law, not to merely convict, and a prosecutor should not permit their professional judgment or their political interests to reign supreme. Saying all criminal defendants, this is the states speaking, saying have a right to a fair and orderly process. The gravity of this particular prosecution is the more reason to ensure that right. And so for reasons unknown, Jack Smith, we know, has sought and secured an expedited trial and an expedited appeal. But this court's Rule 11, talking to you, SCOTUS, requires more than just a vague government interest in a speedy trial. The United States has not shown that its plan to take President Trump's trial to trial in March is of such imperative public importance that requires this court's intervention. And so this court should deny the writ for certiorari, and they did, because they make a good case. Signed off on here by 19 states, not including our loser attorney general here in Arizona, who is not doing anything. But this is United States of America versus Trump, and Jack Smith, of course, lost that one in very nice form. And so what is this about? It's not about justice. It's not about, Jack Smith saving American democracy. It's about political lawfare. And Newt Gingrich explains this quite nicely. He showed up on WABC, the Katz and Cosby show, explaining what the Colorado decision and what this lawfare, this election interference, which is happening right now, means.
Well, it's insane, and it's pushing us towards a civil war. I mean, let's start with a couple of simple facts. 4 lawyers in Colorado ruled that the 360,000 people who voted for Trump in 2020 do not have the right to vote for him. Now, that's about something on the order of 350,000 voters per lawyer. And what they're going to do is destroy, these guys aren't judges. These people are thugs who have replaced the rule of law with the rule of power. And what they're not thinking through is, the Lieutenant Governor of Texas, you want Texas to take Biden off the ballot? The number of states that have Republican House, Senate, and governor, this thing just becomes a nightmare. And it's insane. I think we need to understand this. We're now dealing with a mental aberration in the Democratic Party because they are so terrified that Donald Trump is going to break up their establishment that they're doing everything they can to rig the game and basically holding him hostage because they're afraid he'll win. I've never seen anything like this. At every level, this is wrong. The 14th Amendment referred to basically people who had risen in rebellion and fought a war for 4 years. There's no point at which it references anybody today. No one has charged Donald Trump with insurrection because you can't, because an insurrection is a unique and classifiable thing. But I think one of the challenges when you interview lawyers is they keep talking as though we're dealing with the law. We're not. Jack Smith has no interest in the law. The judge handling the case in Washington, D.C. has no interest in the law. This is a lynch mob. The 4 lawyers in Colorado resemble Venezuela or Nicaragua or Cuba. They have no interest in the law. And that's why you suddenly have people in California, and I'm sure Massachusetts will come along, and you'll find a number of blue states, the states that have the most anti-Semitic riots, the states that have the campuses most out of control, and they're going to say, oh, this is great. We've now found a new way to try to block Donald Trump from winning despite despite what the American people may want.
They are orchestrating and attempting to do everything they can because the current plan is not working. The indictments were not sufficient, and the ballot removal is the next line of attack. And these people are not interested in democracy. They're not interested in the rule of law. They're interested in winning at all costs. And it's not different than what you see in other countries that we mock for being democracies. Having, lawful electoral systems where people's will is effectuated at the ballot box. And they're doing that in this country. And my question to them is, do you want to live in that country in the aftermath? I think they do. I think they want totalitarian power, but the problem is there's always fractures and fissures, and these people are going to have to live in the same country that we're living in. But as it stands today, they suffered a big blow today. Jack Smith's efforts, the Chutkan-Jack collusion to try to keep this train on the tracks for a March 4th trial date doesn't look like it's going to be happening. A tremendous victory for the defense. Jack Smith got played big time here. He was scrambling, panicking, filing for accelerations and expedited appeals, going to the Supreme Court, trying to leapfrog the Court of Appeals because they tried to time this thing perfectly, and they were pretty good. They wanted to get it right around Super Tuesday. They got it right there, but they couldn't keep it anchored in. And so it's going to be a lot of fun. Now, there'll be other maneuvers from Jack Smith. We'll see if anything else pops up, but we'll be here continuing to cover, my friends. And so thank you for subscribing wherever it is you're watching this. There will be more trial coverage here. Thanks for inviting a friend or family member to come over here and join us as we continue on, and we'll look forward to seeing you on the next one.